Good afternoon, everyone. Thank you for joining us today for the legalities of in-person events. Our speaker today is Jeff Tannenbaum, and he is one of the nation's leading nonprofit attorneys and is also an accomplished author, lecturer, and commentator on nonprofit legal matters. As managing partner of the nationally recognized Washington, D.C.-based Tannenbaum law firm, Jeff counsels his clients on the broad array of legal issues affecting trade and professional associations, charities, and other nonprofits. For 19 years, Jeff practiced law at the Venable Law Firm and chaired its nonprofit practice for most of that time. Among numerous other honors and awards, Jeff was the 2006 recipient of the American Bar Association's Outstanding Nonprofit Lawyer of the Year Award and is one of only 6 lawyers in the prestigious U.S. Legal 500's Not-for-Profit Hall of Fame. Jeff is the author of the ASAE published book Association Tax Compliance Guide, and currently serves as chair of the American Bar Association's Trade and Professional Association Subcommittee and on the ASAE Legal Advisory Council and Public Policy Committee. Jeff, thank you for joining us, and over to you.
Thank you, Michelle, and good afternoon, everyone. I'm glad to be here with you for the next 55 minutes. So I have been my colleagues and I opened Tannenbaum Law Group on January 1st of 2020. 2.5 months later, the pandemic is very much upon us, and we're all of a sudden working remotely. The pandemic certainly threw our firm a bit of a curveball in terms of the path that we thought the firm was going to take. What ended up happening is that we spent much of 2020 working with hundreds and hundreds of associations and other nonprofits, primarily associations, in connection with their planned in-person meetings and conferences, I'm sure which all of you had planned and contracted for, that all of a sudden could not happen in most cases for a while legally, because in many states and cities and counties across the country, it was illegal to hold large gatherings. They were banned in many parts of the country, not all, but in many. There were no federal bans. There was certainly federal guidance from the CDC advising against large gatherings, but those were advisory in nature. At the state and local level, there were many bans that were in place for many months. And that enabled us to help associations utilize a provision in the past, a little notice provision in meeting contracts like hotel and convention center and restaurant contracts called force majeure, which enables, say, an association to terminate a contract without penalty, without paying cancellation penalties, if certain unforeseen events occur that make it illegal or impossible, or sometimes the cause is, say, commercially impracticable to hold the meeting. And we had an extremely high success rate of getting most of our clients out of their contracts with little or no penalties. So we turn the corner into 2021. Vaccines start to come online in the beginning part of 2021. And all of a sudden, everyone is looking toward and excited about having in-person meetings and conferences again. And our role then started to evolve, and these bans on large gatherings in the spring started to be lifted in most cities and states across the country, and they still are pretty much non-existent, and with a few exceptions like Hawaii, those bans on large gatherings don't exist. I believe in California there's certain things that kick in with if you have a meeting over 5,000 people, but that's not going to apply to your chapters. And so then we started spending much of our time, along with all the other legal issues that we deal with, on the COVID-related stuff. We started dealing with advising associations on how to hold in-person meetings, whether they're fully in-person or hybrid, kind of part virtual, part in-person, how to hold them in a safe and healthy way that mitigates the association's potential liability in connection with COVID. Lots of meetings planned. A lot of them were ones that were from 2020 that were pushed back to 2021, summer or fall in particular, some in the spring. And then the Delta variant hits us. And because of that, a number of associations, and particularly, we represent about 450 organizations, but a lot of them, but they're in all different professions, but a lot in the healthcare space. And in the healthcare space in particular, a lot of those associations got very reluctant to hold in-person gatherings, particularly at the peak of the Delta variant. So they were again looking to get out of their contracts if they could. Force majeure pretty much no longer an option for most contracts because of the fact that these bans on large gatherings were no longer in place. So we also have been, and this has been going on now for months, working with associations on figuring out, okay, if we can't convince the hotel or convention center or restaurant to let us out of our contract without penalty, and if they're not willing to do another kind of rebook, postpone for another year, then maybe we have to go ahead and have the meeting, whether it's in person or hybrid or whatnot. But we want to make sure we don't get hit, or this is what we were advising our clients, you need to make sure you don't get hit with attrition penalties. So while cancellation penalties were the focus of 2020, attrition penalties have been the focus of 2021 for most of it, because if you hold a contracted for meeting and you don't meet your guaranteed minimums for sleeping room revenue, if you have sleeping rooms, and food and beverage revenue, which you almost always have, they're guaranteed minimums. And if you don't reach those minimums by a certain percentage, usually 70, 75, 80%, then you get hit with these attrition penalties that are designed to kind of make the hotel or the restaurant or convention center whole for what they would have earned, or most of what they would have earned. And if you get significantly reduced attendance, you're going to have significant attrition penalties, unless the hotel or meeting venue agrees to waive the attrition penalties or reduce the guaranteed minimums, which thankfully many have been willing to do because they're eager to get people back into their properties. But it's a critical component of that. And then for those that really did not want to go ahead, we've had to be a lot more creative. I mean, we were creative last year, but even the negotiating challenges have been so much more difficult for those that don't want to hold a meeting. If you don't want to pay big cancellation penalties, we've had to come up with other strategies, such as doing a rebook to next year, but maybe throwing in another meeting, maybe increasing your food and beverage minimums, other things like that, because the threat of force majeure is just not really there anymore in most cases in a persuasive way, unless you have a really unique force majeure clause. So that's kind of where the path has gone in terms of the legal issues involving COVID. Now I'm talking, that's at a very high level. We're going to delve deep into a number of the specifics, and a number of you posted, submitted questions to Michelle in advance, which she passed on to me. And a lot of them relate to holding in-person meetings in 2021 and ways to mitigate liability risk. What kind of steps do you need to take? Should you have your attendees sign liability waivers in advance? Can you require vaccinations, or can you require vaccinations or proof of a negative COVID test within 72 hours? All of these sorts of questions that we are getting from our clients every day. We're reviewing and drafting vaccination and negative COVID test policies, forms where people are making a request for a reasonable accommodation because of medical conditions that prevent them from being vaccinated, and all of this other bucket of related issues. And I plan to talk about that, but let me see if we have any questions here. With that as overview, we don't really have any questions yet. So let me start out with some of the questions that were submitted, and then feel free to follow on and ask post questions in the actually I was looking in the chat box, but frankly, post them in the Q&A or post them in the chat, and Michelle will kind of pose those to me as they come in. But let's start with in-person meetings. So one of the questions I get all the time is, with COVID being such a dangerous, risky, highly transmissible virus, particularly the variant being even more transmissible than others, what sort of liability risk does my association have if we go ahead and hold an in-person meeting this year? So the short answer is that to avoid liability, if someone were to contract COVID at your event and could prove that they contracted COVID at your event, which obviously is, as you all know, a very difficult thing to do, but not so difficult if you had an outbreak where a bunch of people came down with COVID at the same time and they were all at your event. That sort of contact tracing would provide some strong evidence that they did contract COVID at your event. If that happens, can the attendees that contract COVID come after you for any medical expenses, pain and suffering, other things as a result of contracting COVID? Well, if they did, they would have to be able to prove that your association, your chapter, was negligent in how it held the meeting. It's basic negligence law that is something that all lawyers learn in first year torts class in law school. And negligence liability, tort liability has several elements. One, though, is did you fail to meet the prevailing standard of care that existed at the time of you holding your event? Did you fail to meet the prevailing standard of care? That's the real question. So where do you find this standard of care? Well, unfortunately, you don't find it in just one place. You have to look in several different places, and it's a rapidly moving target. So first off, you look to any legally binding mandates. So for instance, in DC, where I am at, there is an indoor mask mandate, regardless of vaccination status. So if you were holding an event, say you were holding one in DC, and it's indoors, you have to impose an indoor mask mandate and enforce it. And if you don't, someone could argue that you're not meeting the prevailing standard of care because that's binding. When you look not only to the state, but you look in California, there's been a whole varying array of mandates over the course of COVID, from various cities and counties. And then of course you have issues about some counties not enforcing statewide mandates, which I'm sure you're all very familiar with. But regardless, whatever is in place and is legally binding from the state, city, or county level, you need to make sure you follow. Where do you go next? Well, next you look to the CDC, which has guidance for large meetings on their website. It was most recently updated in July, at least the last time I checked. In one of the articles, I'm going to send around links to some articles to Michelle to share with you guys. It has a link to that CDC guidance, and it's guidance for large gatherings. And it has some very specific suggestions, some of which will relate to the association as the sponsor of the meeting, some of which will relate to the venue, like the hotel or the restaurant that's hosting the meeting. Things like sanitation requirements, ventilation requirements, food service requirements, things like that. And it's a combination. So you, the association, you want to do as many of those things as you can, that you can reasonably do, that you can afford to do, that still allow for a smooth operation of your meeting. And then you want to get the venue to agree in advance to do as many of the things as you can get them to do. So take a look through that. There's a lot in there, but those are the more of that stuff you do, the harder it's going to be for someone to prove that you were negligent in how you held the meeting. What are some other things that you can do in connection with your in-person meetings to mitigate your potential liability risk for being negligent? Well, another obvious one that has come up in a big way, and it's in some parts of the country, it's very controversial, as you know. In some associations, in some industries or professions, it's very controversial, but that's a vaccination mandate. Either mandating that everyone who attends is vaccinated and provides proof of vaccination. Of course, you could do it the other way. You could require vaccinations, but have people just self-attest. And then you have the option of, you could do vaccination or proof within 72 hours of a negative COVID test. You can do it either way. The law seems to be pretty clear, because all of this is evolving and there could be court cases in the future that suggest otherwise, but so far the law is pretty clear that you are allowed to impose a vaccination mandate on your attendees, or alternatively, proof of a negative COVID test if they don't want to show if they don't want to be vaccinated and they wanted to show proof of a negative COVID test. On the proof of the negative COVID test, some associations that are doing that as an option are requiring a PCR COVID test as opposed to the rapid test, which the rapid tests say are not as accurate. And someone just posted a comment about that. If you're going to have proof of a negative COVID test within 72 hours, it would be better to require PCR test. I mean, it's more of a pain because you can't do it at home, but it's going to be more accurate and reliable. And so something to keep in mind. In terms of the proof of a negative COVID test, which most are requiring, in the beginning, some associations were thinking about self-attestation, but I don't really see that as a trend anymore. The proof seems to be a trend. And what I'm also seeing as a trend for those that are requiring vaccinations for their in-person gathering is utilizing one or more of these services, these apps, that your attendees can kind of preload their information. I did one of them for an ASAE event I was at last week with Clear. There's the airline screening company, security company. They have an app called Health Pass. Very easy to utilize. You upload a copy of the front and back of your vaccination card, your photo ID, put information about the kind of vaccine you got, when your doses were, and then they are kind of cross-linked into state databases and whatnot, and they have some sort of verification process. It's apparently not perfect. It's not 100% accurate. It is. There are some ways that people could game the system, but it's more accurate than simply having your staff or your volunteers look at copies of people's vaccination cards as they come into your meeting. And it's also a lot more efficient. It actually shows a QR code that you can scan and things like that. So again, if you're going to require proof of vaccination, I would strongly recommend that you give people the option to utilize one or more. Some are giving attendees like a list of, here's 3 of the leading companies that you can utilize, and we'll accept any of those. I have one last week, earlier this week, a client that said they're going to require everyone to use one of those. It's called Crowd something. I forget the second part of the name, but they say, can we require all of our attendees to utilize this alone, this one app, and they have to do it in advance, kind of streamline the process, cut down on lines and things like that. I said, you can if you want to, but I said, what's going to happen? There will no doubt be some people who come and they haven't done that, yet they have the actual vaccination card or a photo of it, and they can have their photo ID. And my recommendation is you accept that because it's just going to happen. But you want to try to encourage, just from a logistics perspective and a safety and security perspective, to try to utilize those apps. Now, the thing is, those apps, people can do it on their own, and then you can just check the app. That's one way to do it. But another way, I believe, if you want to be able to use the QR code and scan it, you have to pay the company to do that. And it depends on the size of your meeting. It's going to affect the cost. I've heard $4 a person, $5 a person is some of the costs. I don't know all the details about how that works, but from a pure liability perspective, it's definitely safer to use one of those apps than not to. Now, one thing you do have to keep in mind is that there is an exception that you have to make for a vaccination requirement at your meetings. And that is for someone that has a qualifying medical condition that would qualify as a medical condition under the Americans with Disabilities Act that prevents them from being vaccinated, that makes it risky or unsafe for them to be vaccinated. Based on what I've read and heard, under the current science, there's not a lot of medical conditions that run counter to the vaccines and create a lot of risk. There are apparently a lot of doctors who are writing letters suggesting otherwise. And it's a tricky issue, but because these meetings are being held in places of public accommodation, like a restaurant or hotel, that's what makes them subject to Title III of the ADA, the Americans with Disabilities Act. And that's what requires you to make a reasonable accommodation for someone that has a medical condition that prevents them from being vaccinated. But the good news is the easy reasonable accommodation is proof of a negative COVID test. You could say within 72 hours at the beginning of the conference. You could even require it every day. It's up to you. But that can be a reasonable accommodation, perhaps coupled with an obligation on that individual to wear a mask the whole time when they're in any public setting at the meeting. So that's the good news, is that can be the reasonable accommodation. And if you offer that alternative to everyone, the option to either show proof of vaccination or proof of a negative COVID test, then you've essentially built in the reasonable accommodation for everyone. One other thing to note, I have seen a number of our clients, like draft vaccination policies that we're reviewing, make a exception / reasonable accommodation for those with medical conditions under the ADA and those with sincerely held religious beliefs that prevent them from getting vaccinated. Now that stems from Title VII of the Federal Civil Rights Act. But the thing to keep in mind is you can do that if you want to. That's optional. You can make that exception. Again, it's not an exception. It's not like you don't have to be vaccinated. You can just come up with a reasonable accommodation, so long as that accommodation doesn't pose an undue burden on the organization, and certainly requiring proof of a negative COVID test would not pose an undue burden. But you don't have to do that because Title VII of the Civil Rights Act doesn't apply to conference attendees. It applies in the employment setting. So I know most of you guys your chapters don't have like a typical employment structure where you have employees and you might have a vaccination mandate for staff. You probably read a lot about that. In the employment setting, that is the other exception you have to make and make a reasonable accommodation is for sincerely held religious beliefs, but that does not apply. I think what I've seen is a lot of associations presume that that applies. And so they're building that into their conference vaccination policies, but it's not legally required for you to do so. One other thing, then I'll get to some of these questions that I get asked about all the time is, should we require our attendees to click and accept that they agree to a liability waiver as a precondition of attending the conference? And to me, the short answer is absolutely. It's a no-brainer. It's something that's easy to do. It's becoming more and more common. People are used to it. We're not seeing a ton of pushback. While liability waivers are not always upheld in the courts, there are cases where they can be struck down. Like if your association was grossly negligent, a liability waiver isn't going to do anything to help protect you. But most of your chapters are not going to be grossly negligent in how you hold a meeting, and most of the time they will be upheld. It's basically a statement, and it can be short and sweet, that says, I understand that COVID-19 is a very risky, highly transmissible virus. I realize that despite all the health and safety precautions the association is taking, that there's a risk I might track the virus at your event, and therefore I agree to hold the association harmless and release it from any potential liability if I contract the virus at your event. And then we usually couple it with another paragraph or sentence beneath it that says that the attendees agree to abide by all rules that you have in place for meeting attendance, such rules which are subject to change at any time. And then that's kind of leads me, and you can get them to, you want to get them ideally to click and accept that they agree as part of the registration process. Just make sure, it's important to ensure the legal viability of the liability waiver. Make sure they affirmatively click and accept that they agree to those terms. Don't just bury it in with all your other rules and conditions for conference attendance. And then kind of the last part is, what are the rules for attendees, right? Are you, and this is important, because, again, from a liability perspective, but also just to help make it a health and safety, more safe meeting for your attendees. You should have a set of rules like, don't show up if you have a fever or other potential signs of COVID. If you feel sick while you're there, leave immediately. If you later contract, if you later test positive for COVID, be sure to let any of your close contacts you were around a lot during the meeting, let them know that you contracted COVID, things like that. I see here, what if an attendee refuses to leave and they appear ill? Well, you have every right to have security throw them out. There's no question about that. But that should be part of your rules, and it helps make it more enforceable. So those are some of the things you can do. Now, there's another typical risk management tool that has always been important in kind of the risk management toolbox for associations, which is insurance. But the problem is that for all new insurance policies being written and bound, you can't insure against COVID-related liabilities. The insurance carriers just got hammered in the early part of COVID, and virtually every policy that we've seen that's been written, in the last 12 months or more has built in new exclusions for COVID and other communicable diseases. And so, for instance, your commercial general liability insurance policy is the one that in the past would typically provide coverage if someone got sick at your event and they claim that it's your negligence that caused it and they file suit. That's the policy that would step in and protect you. So if you still have a policy, say, that was written and bound, maybe a multi-year policy before COVID, that should provide good protection for you. But, when policies typically come up for renewal each year, and, the insurance carrier has likely built in, from what we've heard, a COVID exclusion to that. So you basically can't get coverage for COVID-related claims. Someone asked, would seating those with religious or medical exceptions separate from the majority of attendees be acceptable? So I think what you're saying is, say you have a vaccine mandate for everyone. It's not vaccine or a negative COVID test. It's just a vaccine mandate for everyone. Again, there's no legal need for a religious exemption in the conference setting. You can if you want, but you don't have to. It's only the medical one that's mandated. And could you say that your reasonable accommodation for them is a proof of a negative COVID test within PCR COVID test within 72 hours? You could even say, and daily proof of a negative rapid COVID test. And you have to wear a mask the whole time, except when you're in your own room. And finally, you need to socially distance from everyone, meaning we're going to have a separate table for those unvaccinated attendees, things like that. Yeah, you can do that. There's politics. There's, some people might feel like, the ugly stepchild and like that, for lack of a better analogy. But there's no legal right, for them to. The law just says you have to make a reasonable accommodation that still enables the attendee to, participate in the essential functions of the event, so long as it doesn't pose an undue burden on the association. And that would seem to do it. If it makes them feel awkward and uncomfortable that they're sitting at the kids' table, so to speak, and they're wearing masks and no one else is, so be it. But you're a private organization. You can impose rules like that. You're still enabling to attend, the core functions. They just might be seated separately. I don't know that you need to do that from purely liability perspective, but a lot of this is not just driven by the law. We're seeing a lot of this driven by your attendees who are saying, we want to be a really healthy and safe environment. We don't want to worry about contracting COVID. There's still a lot of people that are very reluctant to go indoors with large groups and things like that. And so if you wanted to do that, you absolutely could. There are also, if you have a virtual component to your event, we have seen some of our clients that for those with the medical condition under the ADA, that is what the association is offering up as a reasonable accommodation, to just be able to participate virtually. These reasonable accommodations are very fact specific. They're always supposed to be specific to each individual. But generally speaking, I think that would work in terms of a reasonable accommodation. Does serving food at an event introduce any new legal considerations regarding indoor mask exceptions when eating and drinking? So every place, including DC, that has a mandated indoor mask mandate, legally binding indoor mask mandate, say, and even the federal one, like for air travel and train travel, they say, except when you're actively eating or drinking. That's kind of the way the standard is, which is why, I was out at a restaurant in DC last night. When you're walking into the restaurant and through, the main common areas, you have to wear a mask. But as soon as you get to your table or the bar, wherever you're going, you don't have to keep your mask on. And that's how these rules have been interpreted and enforced. And that's how you should do it as well at your event. And look, that is the weak link. And it's hard. I mean, back in the height of COVID, I attended and spoke at a conference, of course, had indoor mask mandate and everything. And they did a really good job. They had food service where in the past they'd have a buffet, but this time they had like a plexiglass shield separating the food from the attendees, and then they had someone behind there or several people kind of serving the food. You tell them what you want on your plate, and then they give it to you at the end of the aisle. I mean, there are big round tables with seating every other chair. There are ways to do that, but the weak link is when they have the stand-up cocktail reception, when it's kind of impossible to do that. And sure, you got to balance the risks. We all know the kind of things you can do to cut down on the risk. Hold it out, and if you're going to hold events like that, hold them outdoors as much as possible. But the food service and drink service element of it is, try to be as thoughtful about it as you can, but you got to balance it all. And you want to give people, people are excited to go back to in-person events, so excited. And you want to, make it a fun experience for them as well, just balancing it all. Someone asked if you can require effective masks, not just cloth masks. Yeah, it's a great question. And I've been hearing more about that. In fact, I was watching the NBC Sunday morning news program, Meet the Press, a couple weeks ago, and there was a doctor on talking about some of these issues, and he mentioned to the host, Chuck Todd, that the cloth masks that so many of us wear, including myself, the test nets show they provide very little protection, better than none, but not anything like an N95 mask or double masking or things like that. And Chuck said, so this mask that I wear every day is providing very little protection, and the doctor said yes. As a result of that, if you wanted to require N95 masks, you could. I think from a practical perspective, if you're going to do it, you need to have them available, or some other higher quality medical grade mask. And you should do that anyway. If you're going to have, even if you don't have an indoor mask requirement at your event, it's just become a best practice for conference organizers to have a box of masks so that anyone who needs one, forgets one, loses one, can have one. And that's kind of a no-brainer. And they're so inexpensive compared to at the start of the pandemic, and easy to get. Someone asked, what is acceptable proof of a qualifying medical condition? So the ADA has been around since, I think, 1990. There's a lot of precedent about this. Again, it's got to be, the inquiry has to be very individual specific, fact specific. You are allowed to ask for instance, someone to supply a letter or note from a doctor attesting to the medical condition and why, in this case, it makes it dangerous for them to obtain a vaccine. I've heard, and from a number of clients, that that this is more in the workplace context, because a lot of employers are starting to go back to the office, and people who either for political reasons or just fear of the vaccine or vaccine hesitancy generally realize they can't just say I'm hesitant or scared to get a vaccine, so they try to hang it on either the religious exemption or the medical exemption under the ADA. And apparently there are both clergy and others who are essentially writing form letters to people. Under the religious exemption, you don't actually have to have any kind of proof of documentation like that. But we've heard of people getting letters from clergy members saying a lot of them relate to religious objections based on how the vaccines were created with fetal cells. And then on the medical side, we've heard of a number of doctors who are just getting paid to write notes, and which in a lot of cases don't have any real medical correlation. And look, if it's you run it by an expert and they say this is just not supportable, it doesn't pass the smell test, you can reject it. The easier thing though would be, and the employment setting frankly is a lot harder. In the conference setting, the reason it's not so hard is that you can just make a pretty easy, reasonable accommodation. You can just, require them to show proof of a negative COVID test and wear a mask the whole time. Or you can, maybe provide them, if you're going to record all the sessions at your conference, you can provide it to them electronically later. Or maybe you have a virtual option where they can log on. There's so many relatively easy and inexpensive options, especially the proof of the negative COVID test, even if you required it daily during a multi-day conference, that it should not be hard to do. So I really don't think I can't say for sure because it's all still very much evolving, but I don't think there's going to be a lot of issues where you need to really drill down on the veracity of someone's medical, ADA exemption claim, because just make the reasonable accommodation. In the workplace setting, it's a lot different and a lot more difficult, but I'm not going to focus on those issues because I don't think it applies to most of you. Let me see what other questions we had here. I think we've talked about most of them, maybe all of them. Yeah, one other, how does HIPAA affect requiring proof of medical condition? So there's really good guidance that has come out of the EEOC. And I will send you an article. I know it's not relevant to most of you about workplace liability and COVID. And in there's a link to the prevailing or the leading or most current EEOC guidance at the Federal Equal Employment Opportunity Commission. And they have a really long list of FAQs, kind of Q&As on a whole bunch of COVID related workplace issues, including vaccination. And what they said, well, first off, HIPAA doesn't even apply to most of your associations. HIPAA applies to healthcare providers and business associates of healthcare providers. And while you guys are obviously in the healthcare space, mental health care space. And you yourselves as medical practitioners or as therapists or whatnot, very well may be covered by HIPAA. Your chapters are not healthcare providers or business associates of healthcare providers. So generally speaking, for most associations, HIPAA doesn't even apply. So it's not something you need to be concerned about. There is a provision in the AGA, in the employment setting, which requires employers to keep all personal medical information about employees strictly confidential and not keep it in their personnel files, keep it in a separate protected area. Again, that does not apply in this setting. But the bottom line is there is no legal protection, even under the California, as you probably know, has the California Consumer Privacy Act. Even there's nothing that prevents you from asking for proof, including showing their vaccine card, their CDC vaccine card to you to show proof of vaccination. Everything that we've read and seen and heard has said that that is perfectly lawful. What the EEOC has said is that don't go further and start to ask more questions about when, whether you can ask for when they got vaccinated. You need to know that to show that they're at least 2 weeks past their final shot. By the way, as we get now into the world of booster shots, we're already working on policies for associations to address that, because in the beginning it was just, did you get your initial vaccination, whether the 1 or 2 shot regimen? But now, with boosters and generally recommendations, which seems it's eventually get extended to the whole population in the U.S. That you get when probably 6 months after the first set of shots or shot, you can require that as an ongoing requirement, because you want to ensure, if you're trying to ensure that everyone who's attending your event is safe from a COVID perspective, you want to make sure they have the full protection of all of those vaccinations. So you can build that in as well. One other insurance related issue that I get questions about sometimes, especially last year. So last year, many associations had purchased what's called event cancellation insurance coverage. And for policies written prior to January of 2020, all of the leading policies had an option where you could pay extra to purchase coverage for communicable disease related claims. So if the claim arose from some sort of communicable disease outbreak like COVID, you would have coverage. You generally roughly paying 20 to 30% higher premium, and you could purchase that coverage. A lot of associations didn't know they could do that, which was very unfortunate, but a number had, and it proved to be invaluable for so many associations last year. One of my clients got an $11 million payout from their policy. Unfortunately, going forward, unless you had a multi-year policy, you cannot pay extra to get coverage for communicable diseases. It's completely gone, and it's likely going to be gone for a long time, perhaps permanently, because the insurance carriers took such a hit on COVID-related claims. And so then I still get the question, well, is it still worth it to buy event cancellation insurance coverage? And, I say insurance has gotten a lot more expensive in the last year. Premiums seem to be up around 30% over last year for virtually all types of insurance. It's expensive. Event cancellation has gone up as well. And obviously you don't have COVID-related coverage, but you still do have coverage for other things, which are very real, unfortunately, in California. Fires and earthquakes and storms and flooding and other things like that, which are perils that are covered by these policies, terrorism. And so it's definitely something, if you have one big event and it's a significant source of your annual revenues, I really think you should consider purchasing it. You always have to do a cost benefit analysis. Someone asked if insurers will not provide protection for COVID liability. Are chapters on their own and required to obtain legal services if someone sues the chapter and perhaps the state association? If there's insurance coverage for liability policies, which is what we're talking about here, and here we're talking about the commercial general liability insurance policy. That basically says if you get sued, I've often referred to it as slip and fall insurance. Someone slips and falls at your events or some analogous situation, and they get injured and they say you were negligent, and they sue both you and the hotel. If you have liability coverage that provides coverage in that situation, then the insurance carrier would appoint defense counsel to defend, and they would less your deductible, they would pay the cost of defending the claim, and if it settles, paying the settlement or any judgment if it went to court. If you don't have the insurance, then you got to pay it on your own. Yes, that's the short answer. No question. Should the protocols used for live events be considered for meetings? Yeah, it's a great question. I'm getting that a lot in fact, I'm going to an in-person client board retreat that starts on Monday in North Carolina. And should you guys use the same protocols? Yes, is the short answer. Again, every association is different. The politics, the culture, the geographic location, all of that has an effect on this. But there are some who are saying, yeah, we are having an in-person board meeting, but if you can't provide proof of vaccination, then you can't come in person. You should attend virtually. And, I think the kind of virtual option, particularly video option for in-person board meetings, is probably going to be with us permanently. And not that it didn't exist before, it did, but it just was not nearly as common. And I've attended more board meetings than I can count in the last 25 years, and that just is not the norm. But I think it will be in the future, and it tends to facilitate greater participation, particularly when you have larger national associations where everyone's spread out. And so far, maybe not as much of an issue for you guys. But yeah, it's the same thing. All of the checklist of issues about how to avoid being negligent, and whether you require vaccinations, whether you require masks, whether you require social distancing, how you serve food, all of those things are the same exact analysis. Granted, if it's a smaller group, maybe the risk is a little bit smaller, maybe it's easier to manage or mitigate, but still, it's the exact same bucket of issues. All right, well, I have covered all of the questions that I got from you guys. Does anyone have any others that you want to pose on these issues, or frankly, any other association-related legal issues? I do a lot of these sort of ask the association lawyer sessions for a lot of chapters, particularly of national associations. As you might suspect, in the last year and a half, most of the questions have been COVID-related issues, but a lot of times get a lot of interesting non-COVID-related issues too. So if chapters have to provide their own counsel to defend themselves, they may need to budget monies to cover this liability. Yeah, I mean, it's not just in this area, it's every area. And that's part of legal risk management. You can never stop someone from suing you. Anyone can sue you at any time for any reason. It might be a baseless case. You might be able to get it dismissed quickly, but it always costs money. Unfortunately, I'm not a litigator, but attorneys are expensive. Especially litigation is expensive because it's complicated and it's never brief for the most part. So you should always try to have reserves, for any rainy day contingency, including litigation. But it's certainly a great point. It's something you should absolutely always try to do. Insurance, despite the fact that there's no COVID-related coverage anymore or coverage for communicable diseases, insurance is a really important kind of tool in the toolbox of risk management. And I was just on the phone with a Zoom call with a client earlier today, and what they recognize is they operate, it's essentially a certification program, and they have a situation where they may need to decertify someone, remove the certification, and and that could have a significant adverse economic effect on the individual in terms of employability and things like that, and that always creates a lot of risk. In fact, to me, that's one of the more significant risks. And there, most directors and officers liability insurance policies do have exclusions for certification and credentialing and accreditation and similar type activities. Not all do, because D&O policies, nonprofit D&O policies vary significantly from one to the other. There's no forum policy like there is for commercial general liability insurance or property insurance. But if that, in their case, that their policy, their D&O policy, I reviewed it, and it excludes claims for those sorts of things. So what most associations do who have an insurance broker that understands the association industry or the nonprofit industry and understands the risks will suggest that they purchase an errors and omissions liability insurance policy, which is designed to cover certification related claims along with lots of other things. And so you have to recognize what's excluded, like D&O policies exclude claims for bodily injury and property damage, whereas E&O policies do not exclude those sorts of claims, and generally speaking, and same for commercial general liability insurance. So short answer is work with an insurance broker who really understands the association world. I don't know if, I have no idea if CAMFT has like a recommended broker that they work with that all of you guys work with, or if there are group policies that are available to all of the chapters. These are things that are done in some other associations that I've seen. But regardless, having a good insurance broker and a good lawyer who can help you navigate these issues is really important. A couple more questions. If the event is held in a hotel banquet room and precautions are followed, wouldn't the liability fall on the hotel rather than the chapter? So it's a great point. And this is kind of what I was getting at earlier. I should have maybe talked about this a little further. Getting the hotel to agree in advance that they will follow XYZ protocols from food service and social distancing, room setup, sanitation, ventilation, hand sanitizer, all that other good stuff that you're all very familiar with. Getting them to agree in advance is really important, A, to make sure it gets done, which is good for the health and safety of your attendees and your staff and whatnot, but B, to be able to show, look, we did everything right. We even got them to agree that they were going to do everything right. They fell down on the job. Therefore, if there's any liability here, it should fall on them. Absolutely, really important. In the end, if someone's going to sue, are they going to sue both the hotel and your chapter? Probably. But if I was a litigator and if I was defending you, that's kind of exhibit A. Look, there might have been some negligence here, but it certainly wasn't on our part. And here's the evidence to show that. And if there's any liability, it's on the hotel. So we should be dismissed, and the case should go after the hotel. Unfortunately, that's part of the problem with litigation, that if it's a fact-specific issue, which it would be in that sort of situation, it doesn't lend itself to kind of an early dispositive judgment, like a motion to dismiss or a motion for summary judgment, because it's fact-based, which means it kind of has to go to the next level, often to a full trial. But regardless, very important to do. Do I have a recommendation to find sample copy for the registration forms? I'm not sure what you mean by the registration forms. If you mean a model liability waiver, yes, I'm going to be providing. We have a model that's on our website. We have a ton of resources on our site, by the way, on all of these and tons of other association-related legal issues. Tenenbaumlegal.com. There's a whole section of publications, which has articles and PowerPoint presentations. And then there's a section called recordings, which has probably close to 100 recorded webinars, most of them over the last year and a half, on all sorts of association legal issues that I encourage you to take a look at. But like I said earlier, I'm going to send a bunch of links to Michelle, and I'm also going to send you some sample policies. And I think we just turned one we did for a client into a model that's like a conference vaccination policy / proof of negative COVID test that you guys should feel free to use as a starting point to tailor it to your own situation. But every one of these is a little bit different, and every association, every chapter has taken a slightly different approach to these issues. And so anyway, but I think you'll find this stuff helpful. Any other questions? Well, if not, Michelle, then maybe I will turn it back over to you, and we can give people back a few minutes of their Friday afternoon.
Wonderful. Thank you, Jeffrey. That was great information, and we're looking forward to the samples and the articles you will be sending us. For the attendees, be on the lookout for that in your email. I'll make sure to forward that to you, and we will also post it on our website so you and your colleagues have access to that. And then just a reminder, we would like you to answer our survey, and we will send that out to you today. And if you do that by Wednesday next week, you are in to win one of three $25 gift cards. And I do see that people are thanking you as well, Jeff. Thank you very much for your time. We know you're on East Coast time, so for us, it's almost 1 o'clock. For you, much later than that. Thank you again, everyone, for attending, and looking forward to seeing you all next time. Thank you. Bye-bye.
Guys, take care.